Start. If a person approaches the court with unclean hands, basing his claim on forged and fabricated documents, such a person is not entitled for any relief. The power of the High Court to be exercised under Article 226 of the Constitution of India is a discretionary power. When a person approaches the High Court under Article 226 of the Constitution of India, either against state or other on allegations of infringement of his rights, such a person's conduct has to be unblamed worthy. In the present case, the petitioners have approached this court with unclean hands and their conduct is blamed worthy. Therefore, this court would refuse to exercise the discretion under Article 226 of the Constitution of India. The Supreme Court in the case of State of Maharashtra versus Digambar in paragraph 19 has held as under. Power of the High Court to be exercised under Article 226 of the Constitution if it is discretionary. Its exercise must be judicious and reasonable, admits of no controversy. It is for that reason a person's entitlement for relief from a high court under Article 226 of the Constitution, be it against the state or anybody else, even if is founded on the allegation of infringement of his legal right, has to necessarily depend upon unblameworthy conduct of the person seeking relief, and the court refuses to grant the discretionary relief to such person in exercise of such power when he approaches it with unclean hands or blameworthy conduct. It is well settled that one who comes to the court, he must come with clean hands. In the present case, the petitioners have approached this court with unclean hands and have made every effort to drag the litigation for the last long 21 years. They have wasted very precious and valuable time of the court. The order sheet of the case bears the testimony of this fact, which is full of adjournments sought by the counsel for the petitioners. Thus, this court feels that the petitioners need to be saddled with some costs, and thus the writ petition is dismissed with cost of rupees 50,000 to be deposited by the petitioners jointly in the Army Casualties Welfare Fund. Another aspect which needs deliberation is that the petitioners have been paid salary and arrears of salary in compliance of the interim order dated 21 to 2005 and the interim order dated 21 to 2005 and the order passed in the contempt petition. Once the writ petition is dismissed, the interim order gets merged in the final order of dismissal of the writ petition. What would be the effect of dismissal of the writ petition on the benefits drawn by the petitioners on the strength of the interim order dated 21 to 2005 is the question needs to be answered. It is well settled that act of court shall prejudice no one, which is based on Latin maxim. This principle is based on justice and good sense and is guide for administrative law as held by the Supreme Court in State of Gujarat and others versus SR Oil Limited and another. This is also encompassed partly within the doctrine of restitution. This principle is found upon justice and good sense and is a guide for administration of law. The doctrine is basically founded on the idea that when a decree is reversed, law imposes an obligation on the party who received an unjust benefit of the erroneous decree to restitute the other party for what the other party has lost during the period. The erroneous decree was in operation, therefore, the court, while granting restitution, is required to restore the parties as far as possible to their same position as they were in at the time when the court, by its erroneous action,